Thank you for joining us for today's webinar. Before we get started, we have a few housekeeping notes. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the question and answer space. If we can't address your question during today's webinar, we'll follow up after the program. And also, please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Note, Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar must be on a computer or laptop device. Credit is not available for joining via mobile devices. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, you can disregard this. So let's go ahead and get started. We're talking about, employee retention credit, why taxpayers are bringing refund suits. And here we are, your presenters. Thought it'd be nice for each of us to give a little bit of an introduction. So let's start with Helen.
Mark. I'm Helen Cooper. I'm an attorney, a tax attorney and a CPA. I sit in Louisville, Kentucky, and my practice focuses on taxpayer planning and defense. I'm really excited to be here today to speak to you all about the employee retention credit. This is a fascinating credit that has evolved over time and really requires a lot of updates because it's changing really in real time.
Right.
Thank you, Helen. And I'm Greg Rhodes, and I'm in the Birmingham, Alabama office. I spend 100% of my time for the last 15 years doing tax litigation and tax controversy. We really pride ourselves in not only doing a good job at trial, but really being on the forefront of coming up with some kind of complex challenges to the Administrative Procedures Act and regulations. And, this area is really oddly exciting for us because there is a lot of room for ambiguity here, a lot of questions with the regulations, and we'll get into some of that today, and really appreciate y'all taking the time to join us today.
And Mark Lloyd, I'm one of the Denton's National Tax Practice co-leaders in the here in the United States. I'm based in Louisville, Kentucky. Been doing tax work in various capacities over the years. I'm a CPA. Started off my career as a CPA. Was in-house for a dozen years, and I've been with Denton's at the law firm practicing as a tax lawyer. So it's all tax all the time. And we're trying to help our clients with their tax issues, either to prevent them or to, in this case, resolve them one way or another every day. So it's great to be talking about the ERC, which is one of probably the hottest issues in the country right now from a tax standpoint. And just to kind of set the stage for those of you who are new to the ERC or just thinking about it, it's a refundable tax credit for businesses and tax exempt organizations that were affected by the COVID-19 pandemic. Eligible employers could claim the ERC on an original or amended employment tax return between March 13th, 2020, which is kind of when the pandemic was officially kind of recognized, so to speak, through December 31, 2021. The ERC was introduced in A form, which was pretty good in 2020. Most businesses focused on the triple P loans instead. Then, some certainly took the ERC. In 2021, however, though, the credit increased from 50% of qualified wages to 70%, and the 2021 credit could also be applied to qualified wages up to $10,000 per employee for any calendar quarter, really increased, the sweetness, so to speak, of the ERC. When the pandemic ended, we saw a lot of ERC refund claims, made on amended payroll tax returns. They continued to be filed, and things kind of started to back up at the IRS. They and the IRS eventually imposed a moratorium on the processing of new claims, and then lifted the moratorium for claims filed before January 31, 2024. So there are a lot of pending ERC claims. And let's kind of look at the timeline. So you can see in March 2020, Congress passed the CARES Act in the triple P. By December of 2020, there was the extension of the ERC into the first 2 quarters of 2021. March 2021, things were still, we were still in the midst of the pandemic, and they extended it. And then, as you can see, the ERC generated an unexpected market response to a large number of refund claims being filed. Greg, can you continue?
Yeah, absolutely. So, just to kind of put also some context to why this timeline matters so much is, it helps inform where we are with the rules now. And, they're vague, and the timeline helps us understand how we got here. As Mark was mentioning, during the time frame that he talked about, we had this pandemic, and everybody, just like everything during that time period, there was a big reaction to it. And so you had, during the first timeline, Congress was encouraging it, the IRS was encouraging, everybody said, let's get this money out, we got to do this. You see a whole lot of stuff promoting the ERC and encouraging people to do it. And then we get to this timeline in about 2023, and all of a sudden I think there was a, oh goodness, what have we done type reaction. This is a way more participation in a way larger number than we would have ever anticipated. And lo and behold, who would have known it? There were some bad actors mixed in with this. And so then we see the dialogue changing until March 2023. All of a sudden, the ERC is on the dirty dozen list. And this is an IRS list of the worst of the worst, quote, tax schemes going on. And you looked at their announcement, and they don't really articulate what's wrong with certain ones. They just say, this is something you really have to be aware of. And then July of 2023, they kind of ratchet that up. They start having seminars talking about the, quote, bad actors in this area, and no longer talking about all the positive points of it. And there's more kind of discouragement from participating in this. And then you get all the way to September 2023, and the IRS actually, imposes a moratorium on the processing of new claims being filed. And, there was a lot of question, can the IRS do this? This was a congressional act. Can the IRS just say, we're not going to process claims? And we'll see a little bit about that going on, but there was a lot of question about that. And then again, in December of 2023, these claims aren't being processed, but we're seeing 20,000 disallowance letters go out, and they're still not processing. And then at the same time, they start issuing these voluntary disclosure programs where all of a sudden the rhetoric is, there's a lot of bad claims, you really ought to rethink your claim. And so we see the start of a lot of programs, which Helen's going to talk about today, more specifically about how do you get out of a claim that you don't think you should take. And then, Helen, if you wouldn't mind going to the next slide, we continue to kind of see this rhetoric step up, but then all of a sudden we had a little bit of, so in 2024, you're seeing the IRS saying, well, we've reviewed 1 million claims and we've denied 10,000 of them or so that show clear signs of being erroneous. They don't really say what the erroneous was. They didn't say that they're continuing to process other claims. And so the tax community and community in general says, well, what about all these other claims? We're entitled to these. And you start seeing a little bit of a pushback. The IRS continues in July of 24 to keep the rhetoric up, but you're continuing to see pushback. And then in August of 24, you know, it's kind of what I think is the seesaw or the pendulum swinging back. The IRS, really based on some pressure it had and some lawsuits that started being filed of, hey, can you really just not pay us the money we're entitled to? They then start actually processing some claims and acknowledging the end of the moratorium. They processed 50,000 claims that they considered low risk. But still, that's a real small number because we still have 1.5 million claims out there that hadn't been processed. And so the commissioner at the time actually came and talked to the ABA tax conference and kind of described what he was going through. But the tax community noted, well, there's still a lot that hadn't been done. And so you continue to see some of the pressure. He at that point announced, we are going to continue on this process of processing these claims, but there's a lot going on. And of course, he's recently stepped down, so we don't know what's going to happen now, and Helen will talk about that. But we do seem to be moving back in the right direction of some of these being processed, which kind of leads you to the question of what do I do now if my claim hadn't been processed? And that's really what we're going to get into today. But I think the context of how we got here is important to how you review your claim now.
Thank you, Greg. And I really like that analogy, the seesaw, because right now, while we have a new administration and we have, you know, the IRS commissioner having resigned and the IRS chief counsel, Marjorie Rawlinson, having left her position, you know, the question is really, is that backward, you know, wave going to continue? Or will we see the IRS go back to its, you know, more of aggressive posturing regarding the ERC? President Trump has nominated former Missouri Republican Representative Billy Long as IRS commissioner. It remains to be seen how he'll go through the nomination process. But you know, one item to note, he has in the past publicly promoted the ERC and drawn some scrutiny from congressional representatives in terms of how he may deal with the ERC as commissioner. He also interestingly once pushed to abolish the IRS. So we'll see how it goes with him if he does get through the confirmation process. It's unclear now whether Long would shift the position of the IRS or if he would potentially recuse himself from ERC matters. We just don't know at this point. But we do know is that one of Trump's initial actions upon taking office was to sign an order requiring all federal employees to return to the office 5 days a week. And he also instituted a hiring freeze. So the reason why this is important is you have to keep in mind that while the IRS has about 100,000 employees, only 28% of those employees are in the office full time. And further, 63% of those employees are nearing retirement age. So previous to this new administration coming in, the IRS had received billions of dollars in funding due to the 2022 IRA tax and climate law, and was going through sort of a hiring spree. Now, the success of that was a little bit mixed, but the intent was to replace some of this workforce that had already been reduced. Now that we have a new administration who's set on reducing the federal workforce, it may shift resources of the IRS from enforcement to taxpayer services and operation support. And so we may see less of these ERC initiatives in the future. On the other hand, you know, we're still kind of in a holding period until we get the new commissioner. And so it's unclear where we'll go from here. And with that, I think I'll let Mark and Greg talk about trends in ERC litigation.
And Helen, I did want to just kind of, you know, I follow along what you were saying there. So we still have this massive amount of unprocessed claims. And, you know, no matter what happens, we do know a few things. There's less funding for the IRS that was already kind of overloaded in this area. There are a ton of, you know, unprocessed claims. So it seems like one or two things could happen. Either the IRS is going to quit scrutinizing them so heavily and start processing them, or they're just not going to process them at all, which will, and kind of blanket deny them, which will lead to more litigation. And that's really yet to be seen. But one of the ways that the IRS sometimes deals with this situation where they've got, you know, a lot of civil claims out there, things that are civil, a little bit of an overload. They know they've got some bad actors. And I do want to stress, you know, the vast majority of these claims are very legitimate claims that the IRS just hadn't been able to get around to, but there are certainly some bad actors. And so, as we'll see on the next slide, the IRS, as they do in a lot of areas, in order to try and discourage the bad actors who they can't catch every claim, they will often go and pursue some criminal cases. And they have said right now that they're processing about 450 criminal cases, looking into them and investigating them now. And then just recently, on January 22nd, we see this indictment come out. And, you know, when you read these indictments, that's kind of, it's meant to catch the attention and discourage and also get people to look. This indictment was about, to just give you some idea of what's going on out there. It was a fake credit repair business, set up shell businesses, no employees, claiming $600 million worth of ERC claims. You know, it's also a pretty good picture of what not to do if you don't want to catch the IRS's attention. These guys were, it was an aspiring rapper. He created a song, said, "I'm really sophisticated," which was abbreviated as IRS and published. And then he even went so far as to have the IRS logo on his CD, which is right there. And so, you know, really all this is to say this is an extreme example of what's out there and what's kind of catching some of this up. And I do think we're going to see more and more of these type criminal actions going on, because it's a way of kind of the IRS dissuading those people and still being able to move on with the other claims.
I can't believe they caught that guy. Flying under the radar.
Very sophisticated.
That's right. So one of the things that so as Greg said, and I think as I alluded to earlier, there's a backlog of ERC refund claims. There are a lot pending. The IRS resources are expected to decrease. The IRS is not being prompted to, and doesn't have a incentive to get taxpayers' money to them. So what can a taxpayer do? Here are a few examples of where taxpayers have recently been filing refund claim actions in order to get ahead of the logjam, so to speak. So there's one out of Arizona where you got Southern Arizona Health Services that is filed a refund suit based on ERC claimed in the complaint. They challenged one of the chief counsel memorandums, which excluded communications issued by OSHA as a qualifying government order. And that's an example of of a taxpayer that's essentially challenging whether or not the IRS guidance is consistent with the statutory requirements. Then we've got JPM Restaurant out of Tennessee. The first one was in the Federal Court of Federal Claims. They're in the restaurant business, and they filed a refund claim related to ERC based on modifications made due to qualifying government orders, which we'll talk about in a little bit. The IRS filed an answer admitting that it had not issued a notice of audit, exam, disallowance, or deficiency to the taxpayer, but contesting the taxpayer's allegations. So in other words, their refund claim was denied, without an audit. And then we've got the Hardy Companies in August, which is a contractor that provides commercial paint and drywall services, and they claimed a refund related to ERC based on both the gross receipts test and the suspension test. The U.S. filed an answer at the end of December, and note that they raised various defenses, which we would expect them to, the IRS to raise defenses, including that their additional liabilities may be owed, and the taxpayer's entire liability for the taxpayers at issue, could be at issue. So that's interesting that they're trying to offset, the claim. So that's certainly a risk, when you bring your refund claim, is the IRS could engage in an offset. But one of the things that then these are just a few, but there's not a torrent of these actions. So you got thousands and thousands of actions that are probably going to go through the regular administrative channels, or that's where they're pending. And you got then a select few are going through, a different route. So it's potentially this could be a way to get around the logjam. Helen?
So as mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. As you can see on your screen, it's ERC. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code ERC into the Q&A session of your screen. Please make sure to hit the send button so that it registers. And in case you miss it the first time, the code word is ERC. All right, so now that we've talked about trends in the ERC, where we started and where we are now, and what taxpayers are doing to push their claims, it's important to talk a little bit about ERC eligibility. So there are several baseline ERC eligibility requirements, and these are statutory. They're actually in the Internal Revenue Code. And that's important because not everything about the ERC and not all of the guidance that we have is in the code or reflected in regulatory guidance. We have a lot of sub-regulatory guidance, meaning it hasn't gone through APA notice and comment. It's more interpretive by the IRS. But what we can be really certain of with the ERC is are those guidelines that are actually statutory and in the code. So there are 3 different eligibility criteria that can be met, or tests, essentially. The first one is the gross receipts test. This is simple math. If the employer experiences a significant decline in gross receipts during 2020 or in the first 3 quarters of 2021, as opposed to their gross receipts in 2019, then they're eligible to claim the credit in that quarter in which they experience the decline. An election may be made to use alternative quarters. Then we have the suspension test, and you see we have kind of a red flashpoint here. That's because this is really the test that we see the most potential for controversy. It's a facts and circumstances test. Essentially, an employer meets the test if they sustain a full or a partial suspension of operations due to an order from an appropriate governmental authority that limits commerce, travel, or group meetings because of COVID-19. And we'll talk about that in the slides to follow. The last one is the recovery startup business test. This is really for any business that or employer that began a business during the pandemic and had less than $1 million in gross receipts for the 3-year taxable period preceding when the credit was claimed. And that one only applies for certain quarters, so it's a little bit less prevalent, although it's still out there. So the suspension test is not necessarily complex, but what it is gray. There are a lot of areas that allow for the judgment of a decision maker and also require evidentiary support. So the first step in meeting the test is to ascertain whether the employer was subject to a government order related to COVID-19. And that order had to restrict commerce, travel, or group meetings in the quarter in which the ERC was claimed. And further, that order has to be tied to a suspension by the employer. So the suspension can either be full, and that's easy, right? You were shut down, you meet the test, or partial. Most of the analysis here is going to center on partial suspensions. A partial suspension could either be more than a nominal portion of the employer's operations. So think, closed for internal traffic, but still doing, carry-out orders in the case of a restaurant, or even a retail store that can't have people in the building, but still can do deliveries. Or it could be due to modifications. So certain modifications that have more than a nominal effect on the operations of the business qualify as a suspension. So both of these tests are subject to a 10% safe harbor. In the case of a nominal portion, we look at the employer's 2019 gross receipts or hours worked for the portion of the business segment that's been suspended. For the modification test, we look at more than a nominal effect on the employer's ability to provide goods or services. That one's a little bit squishier. We'll talk about that one a little bit later. But in either case, if either of those tests are met, then the suspension test is also met.
So the suspension test is, pretty important and we think especially in relation to some of these pending claims because it's a facts and circumstances test. So one of the things to think about is, do you have a full or partial suspension? I mean, most of the if you've got a full suspension, obviously it's a full stop. What we see at least a lot of are partial suspensions, where there's some significant aspect of a business that's business's operations that are suspended. And the other key here is that it has to be as a result of a government order. So you definitely have proof issues, in relation to these. Make sure you can prove, what was suspended, how much of the business was suspended, not only just verbally, but with documentation. And also what government order, was, resulted in the full or partial suspension. So having that government order identified is extremely important. And it's also extremely important to go ahead and make sure you have a copy of that government order if you don't already have a copy of that government order. While these were easy to get back in 2020 and 2011, finding government orders now can be much more difficult. So a couple of points as well. You got multi-jurisdictional companies, a business that operated in multiple jurisdictions and established one multi-jurisdictional policy in response to a government order could be eligible to claim the credit for all of its operations in all locations. So that's certainly something to think about. Voluntary disclosures is one that's not required by our government order, and it's not going to meet the either of the suspension tests. So that's certainly important to keep in mind. Also, the IRS's position is that an OSHA order is not a qualifying government order. One thing to keep in mind, and is the limited supplier exception, which means that if the employer's suppliers who provided critical goods or materials were fully or partially suspended, then that company that was receiving the supplies, the one that's being supplied, could also have a full or partial suspension. So the employer essentially steps into the shoes of the supplier. Now, again, proof is important. So if you're relying on a supplier's full or partial suspension, then you're going to have to, again, identify the government order, and you're going to have proof of that. And some additional comments. Remote work. So, for example, if an operation could not take place, if something that could take place remotely, essentially, it would not necessarily result in a partial suspension of operations. So, for example, where you had typically used to have met in person, but were meeting via video conference over the pandemic, then the IRS would not consider that to be a suspension of operations. There's also a 10% safe harbor, which means that the gross receipts from that portion of the business, it's not less than 10% of the total gross. So it needs to be more than, the total 10%. If that's the case, it's considered not de minimis, and thus could be partially suspended. Often you can look at gross receipts or hours, of service performed. So again, it's important to have documentation. A couple of examples, if you have a retail store, let's close its storefront locations due to a government order, but maintains a website, then it is probably, and that because the storefront locations are more than a nominal portion of the store's business operations, again, you're going to be able to prove that numerically. The business's operations are considered to have been partially suspended. If you have a hospital as an example, which remains open as an essential business, but due to a qualifying government order, must suspend elective and non-urgent medical procedures. If they are more than a nominal portion of the hospital's business operations based on gross receipts or hours of service, it would be considered to be partially suspended. So again, documentation is very important. Helen?
Yes. So in addition to a partial suspension due to a nominal business segment being suspended, there's also an opportunity for businesses that had to make modifications to business operations due to a government order. A modification can be a partial suspension if the modification had more than a nominal effect on the business operations under the facts and circumstances. So here we're really looking at the operations of the business and the changes that had to be made by the business to those operations to comply with a government order. So again, there's another 10% safe harbor. This one is a little bit less certain than the other safe harbor. It's a 10% test, but it refers to a 10% reduction in an employer's ability to provide goods and services in the normal course of the employer's business of not less than 10%. So there's a question there, how do you measure an employer's ability to provide goods and services? And for this, it really will require some thinking in terms of how to quantify operations. Could be gross receipts, could be hours worked like the other test, could also refer to square footage that's been restricted, or certain customers that are not able to come in. But there are certain modifications that are not suspensions, at least according to the IRS's sub-regulatory guidance. And again, this is subject to challenge, but the IRS has said that in their FAQs and in the notices that they've promulgated about the ERC, that changes in customer behavior do not qualify as modifications. The big one is mask requirements. Another one is, fewer customers came in because they were afraid of catching COVID-19. Generally those types of modifications, at least it's the IRS's position that those would not qualify as suspensions. So some examples from those guidance. The first one is a restaurant. So I'm sure everybody remembers, when we started to reopen and restaurants were open, but oftentimes those restaurants were subject to spacing restrictions. So, maybe half the restaurant was, empty, or all the tables were spread out. In this case, where the spacing restrictions have more than a nominal effect on that restaurant's operations, more than 10%, this modification qualifies as a suspension. In contrast, think of a big, retail big box store with lots and lots of space that's probably, never at full capacity anyway. If they're subject to capacity restrictions due to a government order, and they have to make modifications, so they don't let as many people in, they might not actually have a suspension because really, there's not a big change. And I believe the notice here talks about, there's a little bit of a line, to come in, but it's not serious. It's not like, around the door. Those sorts of things are things you want to keep in mind when you're evaluating a ERC claim in its strength. Does it fit within these types of examples? And, what was the severity of the modification? And also, can you establish it factually? Do you have evidence? A lot of times we'll look at policies, employee policies, changes that were made, where maybe aisles were restricted, or certain customers weren't allowed into the business. All of that is important for establishing your claim.
So I'm sure everybody that is listening to this presentation has said, okay, my fact pattern obviously fits exactly within the IRS guidance. So why are we talking about controversy and defense? I make fun of the IRS guidance in this area, but honestly, they've done an admirable job of trying to present various situations, but there's just a million fact patterns out there, and they're inevitably not going to fit with any particular guidance squarely, especially some of the more ambiguous tests. And so there is a lot of room for disagreement, and that will lead to controversy. So one of the things that, I think this is the most important slide, and it's not just because I got to sign this slide, but I do think it presents you with what's some practical things you can do now. Unfortunately, in the area of just tax controversy and tax litigation, things just do not move fast. We've tried cases, I've tried cases involving issues that occurred in 2003 that I'm still waiting on decisions for. The backlog in this area that we're seeing, it's inevitable that, if it does come to litigation in these type cases, it's going to be down the road. And unfortunately, generally the taxpayer has the obligation to prove and document, and kind of has the burden of establishing why he is correct, he or she's correct. And so some things you really ought to think about doing now is reviewing your claim. Helen and Mark will talk a little bit about some options you have if you don't want to go forward with your claim and so forth. And so really the start is review your claim. I think it really helps to have someone that is heavily involved in this area, that maybe wasn't involved with the original claim, review it. They can look at it from a different perspective. Not only that, the IRS guidance has changed over time. There's questions about whether their guidance is really relevant anymore. So I think it makes a lot of sense to have someone, certainly if you're dealing with a substantial claim, to review it. And as part of that process, you're going to want to assemble all the documents that you had that supported the claim. These are very document intensive type analysis. So you're going to want to get that together. Documents have a way of disappearing over time. And unfortunately, the less documentation you have, really the less better off, the worse off you're going to be. The other thing is employees change over time. And so the people that have knowledge about the facts and what was going on in the company, those people change over time. So you really want to document who was there, who can support what, and have that ready in case something does get challenged. And you really want to put this together in a package. As these things go, you claim it, you forget about it, years down the road or however long it becomes an issue. You really want to have this all together. It will help not only if it goes through the audit process, the more quickly and sufficiently you can establish your claim, the more likely that someone that has a bunch of these claims they have to deal with, the more likely they are to sign off on it. Whereas if you lack documentation, it's almost certainly going to go the other way. And the other thing you can do with this process is there is just so much ambiguity in this area. Not only is the IRS notice not clear enough to address all the situations, but this is somewhat kind of a pendulum we were talking about. At one point, this were heavily, promoted by everyone, and so it seemed like there was going to be kind of a less vigorous analysis of your claim and whether to disallow it. Now we're moving back to, I think it's more favorable. We're going to, if the taxpayer was trying to do the right thing, but it's not just a matter of looking at the guidance. It's a matter of also knowing what's going on in the area. And that may change over time about, the legitimacy, quote, or the likelihood of success on your claim. And so it's really a good time to analyze that because I think you're going to need the documentation anyway. Thanks, Ellen.
All right. So what do you do if you receive one of those IRS disallowance letters? So employers that whose claims have been disallowed will receive either a letter 105-C or a 106-C. That's a full or a partial disallowance of the ERC claim. The IRS has published guidance on their website for taxpayers who have received such a letter. And they have also provided specific criteria for how to protest a letter. So while the IRS allows 30 days to respond to one of these, it's also important to remember that taxpayers have up to 2 years to file an appeal with IRS appeals or to file a refund lawsuit in U.S. District Court or the Court of Claims. So one thing, that's a little bit different about the way the IRS is administering the ERC program is one of the things that they did during that moratorium is they examined claims and they developed analytics that they would apply to a broad brush of claims. And over time, they have adjusted those analytics to try to be a little bit more accurate in terms of what they see as potential red flags in terms of the ERC. But what they have not done is done a comprehensive examination on any of these ERC claims, except for, possibly before the moratorium. What they've done instead is they've applied the analytics, and any claim that just doesn't pass whatever criteria that they've established, that claim gets disallowed. So it's estimated that 60 to 70% of these claims will result in letters that will either request clarification or notify taxpayers of adjustments. Because the IRS has not done an examination, nobody's done any meaningful review of the claim already. So, in a typical examination process, taxpayer files a tax return. It gets picked up for exam. The IRS performs an audit. They examine everything, and then they come to a determination. No such, human element has been has touched these. So, it's different from a normal disallowance letter that you may receive. It's really something. It's really gives you a lot of incentive to protest these. That way, there's a human set of eyes, and also that you can put forth all the criteria that do support your claim. So following up on that, the IRS has specific protest requirements related to ERC claims. There's been a little bit of controversy around this, actually, because it asks for things that are not necessarily applicable to every claim. But it's important to try to meet these criteria just so that the process goes as smoothly as possible, and that if you do end up protesting a disallowance, that you can present the best case going forward. So the first thing they ask for is an affirmative request for appeals review. That way it will go to appeals. But it's important also to remember that when you submit this protest, that's not the first stop. The first stop will be with a revenue agent who will perform an exam. So this is kind of like, it's a protest, and it's also sort of like a campaign audit, in that this is sort of the IDR too. This is what they ask for in every claim. They also want an explanation and documentation addressing the IRS's initial reason for disallowing the claim. In every letter I've seen, this has been very vague. It's either, based on your tax returns, we don't think you met the test, or, we don't think, you met a qualifying, you had a qualifying order. You'll have to show documentation of eligibility, explain why you're entitled to the credit, describe your trade or business operations, and present work papers used to compute the ERC, as well as, provide a statement, regarding the calculation of wages.
So how to withdraw a ERC claim? I think it's, again, really important to think about, and just to add one thing to Helen's slide is, and Greg's slide is, you need that packet. You really need that packet of documents that prove that you qualify. That especially contemporaneously document that you qualify for the ERC under whichever test. So let's say you don't. Let's say you don't qualify. You've not received a refund. You've evaluated it and decided, you know what? I think I'm gonna try to I guess minimize my, cut my losses and just withdraw my ERC claim. So there is a process to do that. If it was made on an amended employment tax return, it was filed only to claim the ERC, you want to withdraw the whole thing, the entire amount, and the IRS has not, paid the claim. And here are the procedures, on here. You write withdraw at the top. Send us, you can respond to the audit notice or by just sending a signed copy of the claim with the word withdrawn written on it. If you received a check, you put void on it. So relatively straightforward to withdraw an ERC claim. So refund suits. So if you have filed an original or amended return claiming the ERC, it qualifies as a claim for refund. You can file it if the IRS, you can file a refund suit if the IRS has disallowed the claim, or if refuses to consider the claim, or if you disagree on the amount, then you can bring a suit in the U.S. District Court. Importantly, on the next bullet is 6 months after you file the refund claim, but before 2 years after the notice of disallowance, you can file suit. So 6 months after filing the refund claim, almost nearly every pending amended return qualifies, meets that timing qualification. So you can it may or not make sense to file a refund suit, but in certain circumstances, it might be your best option of getting your money now or sooner. And granted, Greg did note that litigation can take a long time, but going back to the packet that Greg described, where it has all the documents in it that you need, that's the best way to proceed if that's what you're going to do, is to have your refund claim, all the documentation together and ready to go, so that it's very straightforward and easy.
And before we move on too, I just wanted to note two things. Mark and Helen talked about, kind of a lot of timelines that were tied up in what we're talking about today. I think it's really important when you're going through this process to make sure that you're not missing any of those timelines. For instance, there's that 2-year period where you can appeal internally. That doesn't toll the timeline to file suit. So when you're kind of analyzing these, you want to make sure, because we've seen it, where you just want to make sure that you're not missing any of these really relevant deadlines that were referred to in the past slides. And also, a lot of people, we had a call yesterday where someone said, I'm tired of waiting on this process. I want to sue. Do you advise that we go ahead and file suit? And there's a lot that goes into that. It could be expensive, but at the same time, it could move it forward. The IRS certainly is not, they've got issues that they want to challenge, and those are more likely to get litigated. Whereas the more plain vanilla gross receipts type thing, if you file suit there, you're more likely to go ahead and get it approved. So it really depends on your fact circumstances and what are you relying on for the claim, and is there any ambiguity there? But it's an analysis that, a lot of people are thinking about now, and it's worth considering. But again, there's no right decision for everyone. It depends on your facts. And that brings up this next slide, which is Loper Bright, also known as the death of Chevron